Hello, my name is Rob Crossingham. I'm a partner in the Wakeman's insurance team. I'm joined today by Will Healy, who's an associate in the team. The COVID-19 crisis has affected all UK business, and many businesses are now in a parlous financial position. In the circumstances, many businesses will be and are looking to their insurance cover, particularly business interruption covers, to support them. But in the news since the COVID crisis emerged, both the industry and the FCA have reached a consensus that in fact most businesses will not have cover for the COVID-related business losses. In the circumstances, this class of insurance and these types of insurances will carry some controversy at the moment, with some high-profile litigation on the horizon that's also been reported in the press. With that in mind, we wanted to give a snapshot of the certain relevant classes, which we call the Big Five. And this being part one of a two-part podcast on the Big Five covers, today we thought we'd focus on business interruption, denial of access, and loss of attraction. I'll deal firstly with business interruption, and will deal with denial of access and loss of attraction. So looking now then at business interruption as a class of insurance, it's widely purchased in the UK, and as I've mentioned in the introduction, it's in sharp focus now in light of the financial destruction that's been wrought by the COVID crisis. Looking first at the scope of a general BI cover, it might be purchased as a standalone policy, but generally it's found to be added to policies of property insurance and also cyber insurance. In the physical context, with property policies, it will provide cover for catastrophic events, generally such as fire or flood. In addition to fire and flood events, some policies may also offer cover for denial of access or contamination due to certain diseases, which we'll look at later, or also due to government or public authority acts, which may prevent the usual use of a property or business. And again, we'll have a brief look at that later on. As I've mentioned, business interruption would apply both to physical and digital assets. Where it applies, business interruption will cover a business for loss of revenue, loss of profits, loss of rental income where the property relates to the rental out of real property, additional staff costs to cover the interruption of the business, temporary relocation, and where necessary, the incidental costs of reinstating the business, such as commissioning of new equipment once the premises have been reinstated, and retraining of staff. As I mentioned earlier, as to the availability, the FCA now seems to be of the view that cover for COVID-related business interruption losses is unusual. Certainly, as I said, the accepted view of the industry at the moment, both here and in the US, is that only around 20% of businesses at most have cover for COVID-related business interruption. Specifically in relation to the FCA, they published on the 15th of April a further Dear CEO letter dealing specifically with business interruption, where they confirmed their view that such cover is not likely to be generally available, but insisted that where it is, insurance businesses should be dealing with claims very promptly and in almost all cases making interim payments to shore up the viability of those businesses which do have cover available to them. I don't know if, Will, you've got any thoughts on scope of cover before we move on to triggers?
Yeah, I mean, the ABI has also published some communications recently, and they've said that notwithstanding the very significant limits on business interruption cover as a result of the COVID crisis, they still anticipate paying out £1.2 billion in business interruption losses as a result, and that is an enormous loss for the industry, and really I think goes to show that the scale and the extent of the crisis and the financial impact is far more than can sensibly be borne by the private sector.
Yeah, thanks, Will. That's absolutely right. And the point I'll touch on again towards the end of my section of the podcast. also brought up in another of our podcasts in this series on the overall background. Turning now to triggers for business interruption, and in what circumstances this cover might apply, what would trigger the cover in general circumstances. Certainly in relation to physical assets, the standard policy wording would generally contain a material damage proviso, which would require a property to have suffered some form of physical damage before the cover is triggered. Now, in terms of applying that to the present context, so it's quite easy to see how a debate between the insured and the insurers might develop as to whether a property had suffered physical damage as a result of some form of contamination by COVID, or perhaps less so in circumstances where not the property hadn't been damaged or contaminated with the disease, but had nevertheless been prevented from being used by it. So certainly scope for debate on whether damage has occurred, and again, we only have to look at what the industry and the FCA are saying to see what the industry and the city's view of that point is. Some policies in the market will provide cover for business interruption in the event of disease, which perhaps offers a glimmer of hope for insured businesses. The diseases covered under those policies are often specifically listed in the policy, or sometimes referred to specifically as, or rather more generically, as notifiable diseases. That broader description of notifiable disease is generally considered to be defined by reference to certain health protection regulations, which require the healthcare authorities to maintain a list of notifiable diseases, and that list is constantly updated. Insofar as there may be covers out there with that type of insurance available, it may be significant in terms of the timing and availability of cover for COVID that disease appears to have been added to the list at around 6 o'clock in the evening on the 5th of March. So again, one can see scope for debate as to how the timing of COVID being added to that list might affect the scope of cover where there is disease cover of that nature. Some policies covering disease outbreaks sometimes also provide cover where there's an outbreak within a certain geographical radius of the insured property. Here again, one can see scope for disputes as to whether there has been such an outbreak within the radius of a certain business, given that the pandemic is general and widespread. But equally, it might be said that because it's general and widespread, there can be no suggestion that the outbreak has occurred within the relevant geographical radius of the property. Again, certainly scope for dispute there, I would have thought. Business interruption policies, as with of course, property policies are obviously dependent on an occurrence happening, a fire or a flood, which would trigger the claim under the policy. And again, one can see some scope for a dispute as to whether a pandemic is an occurrence, which arguably wouldn't have the nature of some specific event which happens at a certain time and place, or perhaps whether it's looked at from the point of view of the government's decision to implement a lockdown, which might be the occurrence, which again might suffer from the same problem of generality. There are, I would have thought, likely to be more nuanced scenarios where, say, a business is dependent on a local public attraction which has been closed, and that situation may inject a degree of specificity that may assist the insured in obtaining cover. And it's worth noting again, as we talked about in the scope section, that some policies also contain BI cover where a business has been shut down or interrupted due to government or public authority act. In general terms, and as a final point, it's hardly surprising that business interruption might not be available to the majority of businesses affected by COVID. We talked about the scale of the financial implications of COVID in another podcast in this series, and Will raised the point earlier on in this podcast. As the ABI points out, in 2019, the UK economy generated revenue of £4.1 trillion and employed 27 million people. Against that background, where probably every single business in the country has been seriously affected by COVID, it seems to us very unlikely that the insurance market would have had anywhere near enough capacity to sustain the losses if there had been widespread availability of BI cover. Looking to the future, the ABI's position is that the status quo cannot continue beyond the COVID crisis, and the industry is looking to a collaboration with government to look at business interruption solutions for future pandemics, such perhaps as the solutions which have been implemented in the US. Will, did you have any thoughts about triggers and difficulties of interpretation?
Absolutely. I mean, when we're discussing triggers, normally or very commonly, one of the triggers is physical damage, just under a standard BI wording. And the presence of or the actual contamination of premises by the virus itself is probably going to constitute physical damage. And there's case law on that, and that will be the relevant case law will be discussed in a later podcast, where we're going to be talking about the most important cases that everyone should be familiar with. But I think that brings into play some equally important considerations, namely, at what point is that damage remediated, and at what point do those interruption losses stop? Arguably, once the premises have been thoroughly cleaned and decontaminated, then the physical damage has been remediated, and therefore the business interruption losses should stop there. And that would probably only produce a very small loss, and potentially also a loss that's fully within the relevant deductible. So I think a distinction needs to be drawn between situations where the trigger is actually physical damage at the premises or actual contamination, and other triggers, especially non-damage triggers. So that's a good point to switch our focus to some of the non-damage related or non-physical damage related triggers. So I'm going to be talking about denial of access and loss of attraction cover. So, I mean, these are both interlinked, so it's sensible to consider these together. So starting with denial of access, cover that is intended to provide an indemnity where the interruption to the business has not been caused by direct physical damage to the insured premises, but to premises which are nearby or in the vicinity of the insured premises. And it's not hard to see why businesses might need that cover, and some businesses are far more vulnerable than others to this. So, for example, retail premises in shopping centres rely on customers gaining access to the centre in order to generate footfall, in order to generate profit for the business. And you normally see these sorts of claims where, for example, there's been a fire at premises nearby, which means that roads have been cordoned off and people can't physically access the premises, or where there's been a gas leak and premises have had to be evacuated, or there's been a criminal incident, which again means that the place has to be cordoned off and people can't physically gain access. So the trigger for cover is some kind of prevention or even a hindrance, which is a sort of a less demanding trigger to access or to ingress or egress from the premises. And the most important thing to emphasize is that the first stage in carrying out the analysis is always, what does the policy wording say? What are the terms of cover? So some clauses will say, well, there has to be physical damage to other premises. So in the case of the COVID-19 crisis, most of the potential claims, at least, will arise from the fact that premises have actually been ordered or recommended to close by the government. Now, where you've got a requirement for there to be physical damage, the mere act of governmental authority in ordering premises to be closed probably wouldn't be sufficient to cover. Where the wording is more liberal and talks about things such as acts of governmental authority and doesn't specifically reference physical damage, then the position is a lot more nuanced, and there is definitely scope for businesses to say, well, I purchased cover for interruption to my business. The cover included circumstances where I can't access the premises in order to trade. The government has said I need to close, and therefore the loss that I'm suffering is exactly the type of loss that's envisaged by the policy. Now, I'm almost certain that there's going to be some case law on this in the near future. I think the stakes are too high for insurers to accept those on a case-by-case basis, because a lot of businesses are kind of banding together at the moment. I think there's a lot of publicity regarding the claims against Hiscox in particular, and it's very clear that the loss assessor community, some of the claimant law firms, the insurance claimant law firms, are kind of banding together. So if there's a settlement in respect of one case, then that's likely to set a precedent for other cases. So I anticipate the insurers will need to take a fairly firm line on this in order to avoid losing their shirt. I think a similar considerations apply to loss of attraction cover. Loss of attraction is designed for businesses that are kind of parasitic on another business or another attraction which generates trade. So a good example would be a pub near to a football stadium. So on match days, the pub would be absolutely packed with supporters, but on non-match days, it could be very quiet. And actually, the difference between that being a profitable business and a non-profitable business is the existence of the football stadium. So the policyholders for those businesses have a real interest in the attraction maintaining its day-to-day operations, and if it doesn't, they're going to suffer a real loss. So loss of attraction is quite an important extension to cover, which is in a similar vein to denial of access. It relates to an incident which doesn't directly affect the premises, but affects premises in the vicinity. So again, similar issues are going to arise. There quite often needs to be some kind of physical damage to the attraction in order for cover to be triggered. In response to the COVID-19 crisis, obviously, large gatherings have been postponed indefinitely. So there's no football, there's no live sport, people aren't going to cinemas, theatres, etc. And is that really physical damage? Well, probably not, no. So it does seem unlikely that loss of attraction cover obviously the first port of call is the policy wording, but it does seem unlikely that very many businesses that have purchased this extension will be able to turn to that type of cover to recover their losses. But the first port of call is obviously the terms of the policy wording, and any insurers that have a more loose form of wording in their policies may find that they're subject to challenge in circumstances where they never anticipated those policies responding to something like a global pandemic. And I think that's an important point. I think the intention of insurers almost certainly wasn't to offer cover for losses arising from a global pandemic unless they've actually affirmatively written cover on that basis. But if that's what the wording says, or if that's what the wording is interpreted to say, then there's a real risk that there'll be a finding against them. I think another important thing to emphasize in connection with denial of access and loss of attraction cover is that there's often a geographical limit to the event that gives rise to cover. So it might say, in terms of denial of access, that there's cover in respect of any instance occurring within a particular radius or within the vicinity of the premises. Now, I think there's going to be some real debate as to whether governmental actions in response to a global crisis that affect the entire country will constitute or will trigger cover in circumstances where it's limited to a particular geographical area. Does it matter that the event affects not only the area specified in the policy condition, but the entire country? No doubt that that's something that will be addressed in the near future in potentially litigation. So to summarise, the COVID-19 crisis is, it's fair to say, unprecedented for the insurance industry. The last big crisis, the last big pandemic crisis that we had affecting Western Europe was the Spanish flu in 1918, and the insurance market was very, very different then. So insurers are really getting to grips with the pressure that's being placed upon them and the tests that are being applied to some of their wordings. And it will be very, very interesting to see how some of those pan out. There's a very little case law on denial of access, loss of attraction and business interruption insurance generally. So it will be very interesting to see how the jurisprudence develops on this topic. That's all we had to say in this podcast. We hope that you've found it interesting and informative. And if you have any questions about it, please don't hesitate to get in touch with us. We will be hosting a further podcast, a part 2 of the Big 5 covers discussing event cancellation and infectious disease. So we hope you can tune in and listen to that. Thank you very much.